good morning, good evening, or good afternoon, as the case may be. Arcadia Hinescu, you may see her also on video, is a member of the Bucharest Bar with almost 20 years of legal experience. She's a doctor of law from the University of Bucharest with a specialization in civil, commercial, and intellectual property law. Arcadia is passionate about art law, has organized exhibition and has been a member of the Romanian Art Collector Society since 2007. And Ariadna Matas, so you can see her also with video. She has a master in intellectual property law, which I was very impressed, and I want to do this master as well. So if possible, I will look it up. She specialized in policies governing data sharing in the cultural heritage sector. She plays roles in several organizations. How I found out about her and her expertise was from Europeana. She will share information about this as well. She supports the Europeana copyright community. She contributes to the Spain Federation of Library Association IP group, among others, and she participates in NEMO's working group on digitalization and IPR. I would like to invite Ariadna Matas to have the floor, and then Arcadia Hinescu.
Great, thank you, Oana.
Yeah.
Okay, great. So thanks for the invitation. So what I'd like to talk to you about today is copyright, but from the angle of cultural heritage and more specifically digital cultural heritage, which is what we work on at Europeana. So I'll first tell you a little bit about what this Europeana is. So Europeana is a project that was born about 15 years ago from the initiative of member states of the European Union who were seeing how Google was coming in with big chunks of money, knocking at the doors of national libraries and saying, hey, I've got the money you need to digitize all your heritage, but we'll make it available to the public under the conditions that we decide. So member states were a little bit worried about this tendency and wanted to make sure that Europe, the European Union mostly had a project for digitizing its cultural heritage and making sure that it was available to everyone under fair terms, let's say. So that's how Europeana was born. Europeana is now run by a foundation, the Europeana Foundation, and it is connected to another pillar of the organization, which is the Europeana Aggregators Forum. The Aggregators Forum is a network of what we call aggregators, which are intermediaries that work with libraries, archives, museums based in various European countries who have made efforts to digitize their heritage and want to make it available to the public as widely as possible. So what then Europeana does is act as a space where all of this material can be made available online to gain more visibility and especially to be able to connect it with each other. So if a Romanian researcher is interested in looking up some French amateur films from the 60s, they, instead of going directly to a French institution, they may be able to find it directly here. And by doing that, they may be able to find other films that are related to that specific topic. So if you go to europeana.eu, you will find lots of cultural heritage that has been digitized and made available online from all types. So there's like books, photographs, newspapers, magazines, postcards, films, sound recordings, interviews, etc. And my colleagues make a really nice effort in order to try to group things by topic to facilitate the search and the navigation, not only for specialized audiences, but also for those who have an interest in just culture in general and want to learn a little bit more about what cultural heritage institutions have to share. So as I was saying a little bit about the history of Europeana, the reason why we exist is almost to make sure that this material goes back to the public. It's our heritage It's digitized by publicly funded cultural heritage institutions, and very often it is in the public domain, not always. So our goal is as much as possible to make sure that this content is available to the public and that the public can make the best use of it, because as we understand it, that's how we maximize the positive impact of cultural heritage. And that this is very much in line with what a cultural heritage institution like a museum or a library is there to do, which is preserve but also disseminate cultural heritage. So on Europeana, you'll also find some really nice examples of how various types of audiences, from teachers to researchers to creators, have been finding interesting material and using it in their own activities. And making that possible, which means lowering the copyright barriers, is one of the things that we strive to do as much as possible, working together with the institutions that provide this content. So I've been slightly touching upon the concept of copyright, and it plays an incredibly important role in making this reuse possible or not. So we've been trying to support, as part of what Europeana does, we also have a network of professionals that we call the Europeana Network Association, that anyone interested in cultural heritage from the digital perspective is welcome to join. And one of the things we do, as Oana mentioned, we have a specialized group on copyright that tries to develop good practice solutions for libraries, archives, and museums from all over Europe to figure out how to solve some of the copyright challenges that they come across. And our experience from working with these audiences is that copyright has very, very often been seen as a barrier to making our objectives of dissemination and preservation possible. But it's a barrier that plays a role in certain sectors that we need to learn to work with and to figure out solutions for. It's just that in the context of cultural heritage, where the rights holders are often unknown, it's really, really complex to figure out solutions to still make this content available to the public. So, for example, some case studies that we looked into back in 2016 clarified how for some cultural heritage professionals, the cost for clearing rights, meaning to obtain permission from the rights holder for one work, can vary from relatively little to relatively a lot, 27 euros per work, which often exceeds the economic value of the work themselves. So we might be talking about a collection of amateur photography that someone had at home, brought it to the local archives because the photographs were interesting from a cultural perspective, but were never exploited in commerce. The photographer is completely unknown and has never made a business out of it. So they have cultural value, but not necessarily economic value. However, the cost of trying to find the rights holder in order to get permission, in order to make this available online, is often really high, because in here we're talking just about one item, but it generally comes with collections of hundreds and thousands of works. So another testimony shared that clearing rights has been particularly complex for the audiovisual sector and audiovisual libraries, because of the fact that audiovisual material has various layers of rights that need to be cleared separately. So in a collection of 1,000 works, 1,000 audiovisual works, in reality, there's a lot more than 1,000 rights holders that need to be contacted, because a single film might have various rights holders, from the music composer, to the interpreters, the actors, the costume designer, etc. Another testimony, in this case from the British Library, which is the National Library of the UK, they shared a project in which they wanted to digitize 220 analog recordings of oral histories with jazz musicians from the 80s. And they spent about 2 years, from 2005 to 2007, to try to successfully clear copyright and to find the rights holders, which they estimated were about 200 different people. And even after taking the time to go through the process, they only managed to obtain permission for half of the cases. So if it's costly, lengthy, and sometimes a process that sometimes doesn't even lead to positive results. So here's the kind of the bread and butter of bringing copyright together with cultural heritage, is that cultural heritage institutions who have the public interest mission, sometimes established by law, sometimes just by policy, but who are there to precisely preserve and share cultural heritage, are faced with the fact that this cultural heritage at stake is subject to exclusive rights that may represent a barrier to the exploitation of the work in line with the public interest mission. So diving a little bit more into copyright, some of you might be familiar with the idea that copyright was created with the idea of encouraging innovation and creativity, with the idea that by giving an author a set of exclusive economic and sometimes also moral rights, the author would feel a lot more comfortable in sharing the work with the public, because the author would have a way to control what would happen with the actual work. So society would benefit as well, because authors would share a lot more their creative materials, and therefore we would be able to feel inspired from one another, to find inspiration in each other's creations. And so as a result of the establishment of these exclusive economic and sometimes moral rights, the author or rights holder, if the author transfers the rights to someone else, has sort of the power to decide whether the work can be used, and if so, under which conditions. Later on, what has been, because of the raising of the awareness raised by many different types of institutions and individuals, from the reusers, like generally creators, or from schools, researchers, universities, etc., they flag the fact that sometimes it's a little bit difficult to obtain permission, and that this might hamper the exercise of some public interest activities. And that's when copyright systems started recognizing exceptions and limitations to copyright. So a set of specific situations in which asking for permission is not necessary. So it's an exception to the general rule by which permission is generally always necessary if you do an act of exploitation. And so there's a number of situations, depending on your national jurisdiction, in which you will be able to conduct a specific exploitation of a copyright-protected material without having to ask for permission. And it sometimes relates to situations like teaching or private copying or making a citation of a work, etc. These exceptions and limitations have been crucial for situations such as the ones that I was describing earlier, where obtaining permission is super complicated, and it comes to a point where the making available by a cultural heritage institution will probably not harm the interests of the rights holder. And so copyright law tries to find a solution that allows this exploitation to take place. So this is a bit of an overview of directives that touch upon copyright, or that are mainly focused on copyright and related rights in the European Union. And so the ones that are colored in blue bring in, put a particular attention to this notion of exceptions and limitations to copyright. So the Information Society from 2001 established a list of exceptions or limitations that member states in the European Union could choose to include or not. So some did, some only included a few, some included them, but in a very limited way. A couple of years later, the Orphan Works Directive brought in a solution for making available online works in cultural heritage organizations whose rights holders were unknown, and this one was mandatory for all European Union member states to adopt. The Marrakesh Treaty, well, the Marrakesh Directive incorporating the Marrakesh Treaty also was mostly based on an exception to copyright. And more recently, in 2019, the Copyright in the Digital Single Market Directive has brought in a number of exceptions and limitations, some of which benefit the cultural heritage sector, that are mandatory for all European Union member states to incorporate into their national law. And this is this set of exceptions and limitations in the Copyright Directive are the ones that I want to bring attention to now. So the Copyright in the Digital Single Market Directive from 2019, that might seem far away, but member states had 2 years, even though they took longer, to change their national law to bring it in line with the provisions in the Copyright Directive. So we're only starting to see the application in practice of its provisions now. So we could say that it's relatively new in practice. And this directive, among many other things, recognized that there were many types of uses that are new because of technological developments that are not clearly covered within the existing union rules on exceptions and limitations. So these situations in which we're allowed to do certain things without asking for permission, but that are like a bit of an exception to the general rule and exceptional in nature, they should be a little bit broader because there are new situations in which we find a difficulty in making use of certain works in a way that doesn't negatively affect the rights holder. And part of the problem was that the previous directives established these exceptions in an optional nature, so not mandatory for all member states, which means that every member state had a different approach to this topic, and therefore the internal market faced more difficulties in functioning because it wasn't entirely harmonized. So in view of the fact that a lot happens in the digital environment and therefore has a cross-border nature in itself, so the European lawmakers considered that new exceptions and mandatory exceptions were needed. So here are some of the things that this directive brought forward. First of all, an exception or limitation for preserving cultural heritage. So what it says is very simple. The provision says that a cultural heritage institution like a museum, a library, or an archive can make copies of materials that are part of its permanent collection for the purpose of preservation. It's quite simple, and it doesn't establish a limitation in the number of copies that can be made or in the technology that can be used for making these copies, because there were some countries that used to limit the copying for preservation purposes to photocopying. Now that there's digital technologies, it doesn't make any sense to use such a like an old-fashioned technology for that. Text and data mining, that's a really interesting one that also puts a little bit of a focus on cultural heritage institutions, but that also benefits other audiences and has been a little bit controversial lately. Text and data mining understood as almost like using data in order to train AI. So the directive defines text and data mining as any automated analytical technique aimed at analyzing text and data in digital form in order to generate information, which includes but is not limited to patterns, trends, and correlations. So analyzing large amounts of data through an analytical technique, which enables drawing patterns, trends, correlations, training a model, etc. So as you can imagine, we're talking about a huge amount of data. If we had to obtain permission rights holder by rights holder, it would probably be really complicated. So that's why that's one of the areas where the lawmaker decided that an exception to this rule of having to ask for permission might be necessary. What the lawmaker did was say, from now on, it will be okay to make reproductions and extractions, so no sharing online of the actual work, just making copies and extracting information of materials or protected by copyright or neighboring rights to which you have had lawful access. So if you're downloading it from a pirated source, for example, that the exception or limitation wouldn't apply anymore. Made by a research organization or a cultural heritage institution for the purpose of scientific research. So the baseline here is a research organization and a cultural heritage institution, as long as they have lawful access to copyright protected material, they can analyze it without having to ask every rights holder for permission, as long as this AI application is developed for the purpose of scientific research. And this is something that the rights holders cannot oppose. Then there was a second article on text and data mining, which said anyone else can also make this type of use. So anyone else can also exploit copyright protected material for text and data mining purposes. So for applying an analytical technique, unless the rights holder expressly reserves this use. So the content might be available online. This means that I, as a journalist, can kind of crawl it and download it in order to analyze it, to apply text and data mining techniques to it. unless when I go online and find the material, the rights holder has put in a sign of no data mining or no AI, let's say. There's a bit of a controversy around what this sign should look like. The directive suggests that it would be useful for it to be machine readable so that it's not only visible in the human eye, but that machines can also identify content that should not be data mined. But well, there's a lot of people trying to develop standards that facilitate this opt-out option by the rights holder. So to sum up, before the 2019 Copyright Directive and before it was transposed in member states, analyzing large amounts of in-copyright data, because it implied making a copy, processing it, storing it, was most likely subject to permission from the copyright holder. So analyzing large amounts of data was very tricky from a copyright perspective for AI purposes, for example. Whereas after the 2019 Copyright Directive, the exceptions established there clarify that analyzing these large amounts of in-copyright materials is possible without permission, but the rights holder can decide to actively signal an opt-out, and in that case, this content cannot be used for that purpose. And then that this opt-out, this signal by the rights holder, can never stop data mining by research and cultural heritage organizations. I don't know if that makes sense. I wanted to share, so this topic is a little bit controversial, and I'm sure we can maybe tackle it during the questions and answer session. And it's a bit controversial because there seems to be a huge debate between the big AI companies and the cultural industries or authors. And this debate which is super tense, seems to dominate the AI conversations. What I wanted to share is just that there's other applications for AI for which these exceptions and limitations can be extremely valuable for the public interest, hopefully without harming any creator's interest. And I wanted to share just this video which explains how cultural heritage institutions are actually benefiting from being able to analyze paintings, letters, etc. through artificial intelligence, thanks to these exceptions and limitations. But I think in order to play, for you to hear the video sound, I need to share I need to share by allowing share sound, sorry. So let me try now. Do you hear that sound? Okay, great.
What is a painting? Is it the pigments used? Is it the artist's name? Is it its history and context? Do the events and characters depicted define a painting? Cultural heritage professionals aim to improve the way we understand paintings by generating thorough descriptions of them. Not just the aspects around its creation, but specific insights about its visual content. Why is a man holding a lily? What is the meaning of a dog in a portrait? But with millions of cultural objects created throughout history, completing such a task seems impossible for humans. Artificial intelligence is a powerful way of analyzing tons of data. Researchers and engineers are creating rich descriptions for thousands of paintings to train artificial intelligence models, so these can in turn analyze many more thousands of paintings automatically. These models can detect and identify objects and images not seen before. Other tools, like knowledge graphs, can guide the inference of relationships between the objects in an image. Yet others, like natural language models, can refine the objects and relationships based on a common usage in language. A man with a horse and a sword becomes a knight. A man with a horse and wings doesn't. In the St. George on a Bike project, the Barcelona Supercomputing Center and Europeana are building artificial intelligence systems to describe and classify art pieces automatically. Our work could improve the experience of the visually impaired with better descriptions, curate virtual exhibitions with related paintings from around the globe, study hidden relations between thousands of items simultaneously. But above all, this work will serve as the basis for a new way of exploring and understanding our vast cultural heritage.
So, okay, so this was one of the other topics, text and data mining, when we can, because of its links to AI, maybe it's something worth discussing later, but I wanted to offer some of the baseline information and how it can also support some cultural heritage activities. Another huge topic for the cultural heritage sector tackled in the copyright in Digital Single Market Directive from 2019 are out-of-commerce works. So let me start by explaining the problem. Europeana, back in 2015, looked at the content that had been digitized in libraries, archives, museums, and that had been made available online via Europeana. And there was surprisingly a huge gap in the second half of the 20th century. We call that the 20th century black hole. And from conversations with cultural heritage professionals that had been working with this material and making it available online or not, we understood that probably the main reason for this gap was that it was super difficult to clear copyright, in particularly a set of materials from the 20th century. So later on, it's easier to be in touch with the rights holder. Before the 20th century, it's easier to determine that the material is most likely in the public domain. But in between, there's a lot of material that is subject to copyright for which the rights holder is unknown and really difficult to identify or locate. So this problem has been one of the biggest issues that the cultural heritage sector has had when having to clear copyright. And one of the solutions that the 2019 directive brought forward was the so-called out-of-commerce work solution, in order to try to make it possible to make more content available online without permission being in the way, let's say. The deal was to find the equilibrium in just working with material that is not in commercial circulation. Because if it is, we understand that there's rights holders are interested in exploiting it, and therefore we shouldn't be making it available online or on our own in order to avoid hampering their businesses. So the idea is that when a cultural heritage institution like a library, an archive, or a museum has material in its collection that is not commercially exploited, so it's not in commercial circulation, like, for example, a film that was once distributed, but it's no longer distributed through the usual channels, music that is not available in any commerce except for some secondhand shops, which is very difficult to find, books that are not sold in the usual channels, etc. So it can be any type of material. This cultural heritage institution can approach a collective management organization. Every country has a number of collective management organizations. I suppose you're familiar with some of the ones that your country has. Their role is to act as a bit of an intermediary. So as an author, you register a repertoire of works with the collective management organization, which will be in charge of collecting the revenues from those exploiting your work and then giving them back to you. So the idea is that the cultural heritage institution will go with the big bag of amateur photography that they have in their collection that are not commercially exploited, to the collective management organization in its country working with that specific type of material. So, for example, a visual arts collective management organization. And this organization will be able to give the cultural heritage organization permission on behalf of any author in the specific domain, even if the author has not given the collective management organization permission. So what's really new here is the directive has given collective management organization. What's new here is that the directive has given the collective management organization a bit of an extended representation power just for the purpose of giving permission for making available out-of-commerce works. That makes it possible for the collective management organization to give permission without having to go item by item, checking whether they have the author in their repertoire or not. In most cases, they will not, because it's materials whose authors were never intending to exploit this in commerce, or very rarely. So the result will be that these two organizations will conclude an extended collective license agreement. And on the basis of this agreement, the institution that has these materials on its collection can make it available, can make these materials available online. Instead of having to clear permission from 200,000 of authors, they can simply conclude one contract and make the material available online. Only in situations where the collective management organizations in the country do not work with this type of material, then the cultural heritage institution can go ahead and do that same thing without having to obtain a license from anyone. It's important to note that rights holders or authors can opt out at any moment. So before the making available online, or while the material is available online. So they can approach the cultural heritage institution and say, I don't want my content out there, and the institution is forced to take it down immediately. This out-of-commerce work system is a bit of is kind of the successor of the Orphan Works Directive that I shared earlier, which has been a disaster. The directive offered a first attempt at solving this problem, the Orphan Works one, by saying any material for which you do not know the author, or the author is known but too difficult to locate, you can make them available online, but first you have to follow a lot of conditions. And these conditions were so cumbersome that the cultural heritage institutions barely made use of this directive, only in certain circumstances. That's why there was a review of this directive. The Commission clarified that it had been very difficult to apply. They didn't remove the directive because it was used by some institutions still, but they decided through the copyright directive to actually offer a much improved, better solution. And the last topic that I want to talk about is just works of visual arts in the public domain. So I've been talking about the fact that cultural heritage institutions make content available online. It's super complicated, and we need exceptions and limitations when this material is in copyright, but there's a lot of material in cultural heritage institutions whose copyright has expired. It's in the public domain, and so there's no rights holder who can exercise any rights. In these situations, what the institution could do is simply digitize it and make it available online, citing the author, etc., but without any needs to ask for permission, simply because copyright has expired. However, we've been seeing a very problematic practice of some institutions saying, I'll make a digitization, but when making the digitized copy available online, I'll still claim copyright, which is really problematic because this material is in the public domain for a reason. Copyright has an end date for a reason. And the reason is that society should be able to benefit from the creativity of others at some point. And so it's really unfair that a cultural heritage organization decides to block the possibility to reuse this material. The reason why they've been claiming copyright in digital reproductions is that they claim they have, in certain countries, there's these related rights on non-original photography, which were claimed by this cultural heritage institution by saying, I'm making a digitization which is an analog form of reproduction to photography, and therefore I can claim this new copyright just on the digitization, which lasts for less years than copyright protection, but still gives them a couple of years to control who gets to use the work under which conditions. Well, this doesn't make any sense and goes against the principles of copyright law, but also of the public interest that these institutions should be working towards. So that's something you'll come across a lot if you work in the digital humanities. You go into a big museum's website and you will find copyright claims by using the copyright sign in the metadata or in their terms and conditions for material that is in fact in the public domain because the author died many, many years ago. So there's some people in our networks who have been doing amazing work as part of the Open GLAM movement by trying to convince cultural heritage institutions not to do this. So what this map shows is institutions all over the world who have been embracing Open GLAM and saying, making a digital reproduction and not claiming any rights if the material is in the public domain, because it's not for me to decide and because copyright has expired. So this shows a number of dots, but in fact, there should be a lot more dots by now, because it's not the place of a cultural heritage institution to block reuse. Sometimes their concerns are natural, like I want to make sure that the work of the institution in digitizing it and making it available online is recognized, but copyright is not the way to do that. So the 2019 directive brought forward a provision specifically trying to address this problem. And what the provision said is that when the term of protection of a work of visual art has expired, so when a work of visual art is in the public domain, any material that results from an act of reproduction of that work, so any digitized copy of that work, is not subject to copyright or related rights, unless the copy in itself is really an artistic take on the artwork. But in general, what a cultural heritage institution will do is a super faithful reproduction in order for the public to enjoy the actual underlying work, not in order to enjoy a new artwork. So if there's no creative effort in the reproduction, there cannot be any rights claimed on the digital reproduction if the underlying work is a work of visual art in the public domain. So the result is that the museum has the sculpture, it's in the public domain. When then they digitize it and make it available online, they cannot claim new rights and have to establish that or recognize, if anyone asks, or make it clear up front that the reproduction is in the public domain as well. So I think I'll leave it at that. So yeah, no more related rights on non-original photography can be claimed on the reproduction. I will leave it at that. It's a lot of information in many different directions, sorry, but happy to chat about any of these points if you're interested. Thank you very much.
Thank you, Ariadna. Maybe it would be of interest, maybe just to pinpoint or give resources for further reading, the difference between public domain and open access. Well, maybe also open source, which is quite different, but anyway, so that our colleague participants would know what is public and what is open access, and as you mentioned, when to give credit or not. Actually, giving credit, it should be a norm. I mean, you just take something from somewhere and you give your source. I mean, it's no
even
problem.
for correct scientific practice, you want people to know where you got the material from. So yeah, I'll put some links in the chat in the meantime. Then yeah.
Perfect. Yeah, thank you very much. It was very good clarifying and also mentioning the issue, not the problem, the issue with the data mining and with the AI. Maybe we will discuss after Arcadia Hinescu will have her input about the idea of co-creation, but co-creation between humans and between a human and a tool, or a human using a tool which is powered by artificial intelligence. Okay, thank you again, Ariadna Matas. Arcadia Hinescu, please, you have the floor.
Hello, anyone. Hello to all. So thank you, Ariadna, for your very interesting presentation. I like it very much that it has a lot of practical issues, and I'm coming with my presentation more directly related to the Romanian legislation as regards the copyright. And I will also put on screen my presentation prepared, not so wonderful drafted as Ariadna, but I just want to approach some things regarding the copyright in Romania, and hopefully that starting from that you will have questions and I can answer and clarify certain issue that you particularly want to know about. So what is important to know anyone to know that any Romanian author is protected, of course, but by the national law. And here, the main national law that provides on copyright and related rights is law number 8 on 1996. And actually, it is expressly stated in the law that the recognition of the rights provided by this law does not prejudice or exclude the protection granted but by other legal provision. And when we say that, we refer, of course, to other national legal provisions, but also to European legal provision, because Romania is also part of the European Union. So also applied and harmonized its legislation with the European, and put into practice the directives on copyright, such the directive presented by Ariadna on copyright on digital single market, but also, for example, another well-known directive on harmonization of certain aspects of copyright and related rights in the information society as of 2001. And of course, besides that, any author, Romanian author, has protection also from an international legal point of view due to the treaties to which Romania is part of and which become also part of the Romanian legislation. And the most known of this treaty in the field of copyright is the Berne Convention for the Protection of Literary and Artistic Works, that is quite ancient, is from 1886, but still in force and has the base. It proves that for a long time, it was this preoccupation of all to protect authors, and and step by step, such protection was strengthened. So continuing on this issue, I will approach what the main provision of the copyright law in Romania are regarding authors and the works, knowing that although it is national legislation, due to the fact that Romanian law system is based on the German Roman law system, this means that a lot of provision can be found in other European legislation on copyright. So if you can have as a base this kind of information if you are not from Romania, and also check it on your country to see if it is the same provision. And so the first thing that we need to know on copyright is who is the author. So normally the author is the person that considered under Romanian law, the person that created the work has the copyright, and usually is a natural person. So I say usually because there is this possibility that legal entities are also having this kind of copyright following on inheritance or following on assignment of copyrights, which is quite seldom. But the main person who has the copyright, it remains natural person. And what is important to know is the moment when the copyright, the protection of the copyright there is in Romania, but not only in Romania, as I was saying, in most of the European country. And in this way, as regards on this issue, the law says that the work of intellectual creation is recognized and protected independently of bringing it to the public knowledge by a simple fact of its realization, even if unfinished. So this means from the moment the work is created, it is protected, legally protected. This is something specific to the European law system. After the copyright protection started, it has, of course, the copyright lasts during the life of the author, but also the 70 years after its death. Actually, this is the rule. There are some exceptions, but the main rule is that. So quite a long time. And of course, it was thought that if the artist, maybe its inheritance did not succeed in having enough benefits from the work, well, the inheritance also have another 70 years to recover that. As regard the what is actually protected by this copyright, so any original works of intellectual creation in the literary, artistic, or scientific field are subject to copyright, regardless the mode of creation, mode or form of expression, and regardless their value and destination. So what I want to underline is that what the law protects is actually the form, the way the idea is expressed. And so our object of copyrights, books, articles, software, composition, artworks, photos, film maps, and architectural works, for example, but also derivative works. That means that these works are created starting from one or more pre-existing works. And for example, derivative works are translations, adaptation, annotation, documentary works, musical arrangements, or for example, collection of literary, artistic, scientific works like encyclopedias, anthologies, compilation of data, including database. But notice that they are considered derivative works only if the way in which the database is chosen or arranged, the material constitute an intellectual creation. So if it's just gather the information and put it on certain criterion, this is not derivative work. This is not protected by copyright. A thing that I want to insist on is that actually copyright does not cover ideas and concepts. I've heard a lot of time people saying also in the art field, this was my idea, he stole my idea, he stole my concept, this was my concept of exhibition. So what is important to know is that copyright refers to the form of the idea, yeah, to the way it materializes in written, in another material form. So there is not a possibility to protect on copyright the ideas and theories or concepts or scientific discoveries or mathematical concepts. And also, of course, the official text like legislation, administrative, legal decisions, official translation, they are not covered by copyrights. The symbols of a state also, like flag, emblem, seal, the means of payment, news and press information also is not covered by copyright. Simple facts and data, and photos of letters, documents of any kind, technical drawings. So these are not covered because actually there is not, behind these works, there is not a creative activity. And also, as we already talked about, the fact that some of the works have already expired the protection period. And also Ariadna indicated that the materials resulting from an act of reproduction whose term of protection has expired, it is not protected, but it can have a copyright if it represents the author's own intellectual creation. So if the author uses a work that already has expired the protection period, but to create another original work, like for example, to make the portrait of a person using small photographs of works that are already expired from a legally point of view. This kind of work, yes, can be considered an original work, so it can be covered by copyright. What is specific to copyright is that one can create a work, but there are also works that are created by several authors. And here there is a difference in the Romanian law on, and the law makes a difference between a joint work and a collective work. So a joint work, in a joint work, there are several co-authors that collaborate, and usually it is easy to indicate a main author, and except otherwise agreed, the co-authors can use the work by mutual agreement. And usually they cannot oppose just on the fact that they do not want their joint work to be used in or presented or reproduced just because they don't want to do it. They need a reason to forbid this use of joint work. And what is common is that in this joint work is that we can establish who made what. For example, I give you an example, a book with illustration. I can say who is the author of the text, who is the author of the illustration. And for example, each of such authors can use their word in a separate way, as long as they do not prejudice the joint work. As regards the remuneration in this case of a joint work, normally the two or more authors should establish how the remuneration should be divided. In the case such agreement there is not, they can the remuneration shall be proportional. So when I'm saying this, you need to think also that so I guess that you are thinking, oh, where should it be? Why we say unless otherwise agreed? So when there is this opportunity of creating of a joint work, it is normal for the two authors or more authors to have a contract in which they establish each right. They establish the remuneration. If who will exploit the joint work and all this. So I know that it is not usual for authors to do so, because you know the creative act is most of the time spontaneous, and the co-authors usually have a relation based on trust, so they do not think about a contract at the beginning of their collaboration. But it is very useful to have such a contract. So for the future time, if among you there are people that are involved in joint work, it is not too late to make such a contract and establish each part who is doing what, who will use the joint worker in which condition, what will happen with the remuneration, and all of this, so it won't be a problem later when such work should be valued. And so this is the joint work. Besides this, there is the collective work. So this collective work is where there are several co-authors, but it's not possible due to the nature of work to establish which is the participation of each co-authors. So if there is no contract on how this collective work was created, then the collective work belongs to the natural legal person from the initiative, under the responsibility or under whose name was created. In order to understand better collective work, I can give you an example. For example, a newspaper is a collective work. A magazine is a collective work. So usually here, the copyright could be held by the editor. Still, also like in the case of a joint work, it is very important to have a contract stating the way in which the co-workers have certain rights as regards the collective work. Ariadna already told you about the out-of-commerce works that actually are still under copyright, but there is this possibility due to the European Directive to use it under certain circumstances. And there is also a site where you can see which are such works out of commerce. Of course, the Romania also harmonized its legislation and has such provision regarding the out-of-commerce works that was introduced in the Romanian law in 2022, together with the reference regarding the orphan work. But as Ariadna said, in order to declare an orphan work, orphan work, it is very difficult because you need to make a lot of research and make sure that actually no other owners of the rights can be found, which is quite difficult for most of the people, so it's not so useful at this point. There is also on the site of European Union a link where you can see the orphan work. Still, anytime you use a work, you need to make a double check as regards its rights. Want to ask Ariadna about the public domain and open sourcing access, and I would add here versus open sources. And let me see. Public domain here. So as Ariadna said already, public domain includes materials that are no longer protected by intellectual properties. And so anyone can use it without obtaining permission, but you cannot own it, of course, because it is a public domain. And in this case, the legal protection has expired. What I totally agree with the fact that once a work is in the public domain, there should not be found any kind of way to establish new copyrights as regards this kind of work. This is excessive. There are already past 70 years. It is a lot of time. So I think it's the time for the people to enjoy the creation of other people. On the other hand, open access it means resources freely available for viewing or use, but in this case, they are under copyright by their creators, and most academic and educational use is permitted without permission. Even if copying is not permitted, open materials can usually be linked from an online syllabus and reading list. So always check the copyright or permission statement before use. An example of an open access that you probably already know is Google Scholars, which is a search engine that provides access to full text journal articles and preprints and ebooks. So it was find a way to give access, usually on academic education purpose, to materials that are still in under copyright. As regards the open source, this has a license that sets rules for usage, while public domain has no restriction at all. Actually, an open source license is a type of license that allows the source code of a software to be freely used, modified, and distributed by anyone. So such license typically have certain conditions that must be followed, such as including a copy of the license and giving credit to the original authors. What you probably already know is that open sources licenses are usually for softwares, while public domain is commonly associated with creative works such as literature, music, and art. However, it is also possible for software to be released into the public domain. What is interesting to know is that there are these Creative Commons, which are pre-made licenses that creators can attach to their copyright works to indicate that they have waived certain rights. What rights? So they have for sure waived some of their economic rights, because as Ariadna said, an author has moral rights and economic rights. So what is of interest here is the economic rights, because these rights are connected to the fact that work cannot be used not only without based on the consent of the author, but also the consent can be conditioned by a certain amount of money. So of course that sometimes the use of a copyright can be quite expensive. That's why it is very important that there is this directive that Ariadna presented that by which the European legislator find a way to allow the education field, academic field, to have access to work that are still under copyright, of course, under certain conditions. So under the directive that Ariadna presented, she talked about the fact that due to this legislation, the collective management organization had a new power, and this collective management organization are actually legal entities established through free association. So like they can be NGOs, they can be companies, but their sole and main object of activity is the management of the copyright and rights related to copyright, categories of rights, type of works of the other subject protected, and the author entrusts their work to be protected and to be followed all around the world. So in order to be, at least in Romania, but I'm sure that also in other states, in order to create and act as a collective management organization, such entity must meet certain conditions verified by the Romanian Copyright Office, that in Romania is Oficiul Român de Drepturi de Autor, ORDA, which is the sole authority in the terms of recording, observing, and controlling the application of the legislation in the field of copyright and related rights. So ORDA is the entity that checks the collective management organization, establish legal rules as regard them. What an author should do in order to be part of a collective management organization is he has to fill in a mandate by which he grants the power of CMO to represent in operation such collection of sum owed by user, assistant and special consultancy as regards the copyright, provision of information regarding the rights that are the subject of a management contract. So it is very important to know that such collective management organizations are very useful to an author. Why? Because actually an author by himself would be very difficult and does not have the information, the infrastructure necessary in order to check how his work is used and is all around the world. So this collective management organization instead has should have all the equipment to do so and to protect the rights of creators. So one should know that there are a lot of collective management organization based on the field, on the creative field. For example, in Romania, there is Copyro, which manages the right of authors of written works. There is Credidam, Romanian Center for Administration of Performance Rights for the performance. UTMR-ADA, which is the Union of Composers and Musicologists from Romania, Copyright Association, which is for the music authors. Vizarta, which manages the rights of visual artists. And another example would be Dacin Sara, which manages the rights of cinematographic works and other audiovisual works. So it is important for any kind of author, no matter his field in which he is creating, to know which is the national collective management organization in which could represent his rights and help to value his copyrights and give mandate for this. And of course, what is important is that now the collective management organization have a big role in this possibility of accessing the works that are still under protection in order to be, but is not open for commerce, to be used by people interested in education, academic, and in valuing our cultural inheritance. So, of course, that this collective management organization, the national one, are also in connection with the international one. So, as long as you entered in this national collective management organization, you can be sure that the national collective management organization has the necessary means to protect also the works abroad due to these collaborations. So this is very important to be part of a collective management organization. Why they are also important? I could also tell you another reason for which the collective management organization are important is that in the case the author does not have successors, according to the Romanian law, the work of such authors shall be protected for the next 70 years by the collective management organization. So there is somebody that will take care of this work. Because as you know, not always the artists are so well organized in order to plan their succession rights and everything. But even so, what is important to know is if you are an artist, you should, a creator, you should protect the best way to protect your work is to be part and be member and give mandate to a collective management organization in the field of your activity in which you create a work that have copyright. I was telling you about how important is for a person to be part of this creative management organization. They can also help you with advice as regards the temporary export of artworks. You should know that under Romanian law, the artworks created by contemporary artists do not need a special certificate to be taken abroad. Still, there are two types of artworks that need to have a certain documentation in order to be exported. So from this point of view, in Romania, there are three main legal provisions that provide this issue. On one side, there is Law 182 from 2000 regarding the protection of the mobile natural cultural heritage. Then actually it was the decision 518 as of 2004 for the approval of the methodological DOM regarding the definitive and temporary export of movable cultural goods. And the last was the government decision 886 as of 2008 for the approval of the norms for the classification of the mobile cultural goods. What actually provides this kind of legislation where it states over the way in which certain artworks can be exported. What an export means, it means the removal of an artwork, movable cultural goods, so-called, across the border, and this can be temporary or permanent. Of course, permanent in case of a sale. What is important to know is that such export can be carried out only on the basis of an export certificate, which is issued by the decentralized public services of the Ministry of Culture. Like at every county in Romania, so Romania has 41 counties. Each county has the Department of Culture. So such a Department of Culture would give an expert certificate. And it is important to know that if an expert is made of an artwork is made without this expert certificate, it is a criminal offense. So it is very important to have all the legal documentation in order to remove the artwork across the border. The Romanian law says that the temporary export of artworks listed in the treasury, no matter the owner, is carried out on the basis of the proposal of a National Commission of Museums and Collections and must be approved by the Minister of Culture. And still, the artworks owned by the state or the counties, for example, can be temporarily exported and only for the organization of exhibition abroad, laboratory investigation, restoration, and expertise. So all the artworks there are of the Romanian state or of a municipality can be temporarily exported just for this. And in case of artworks that are listed as treasury, no matter if they are owned by natural or legal person under the private law, they can be exported only temporarily. This means that a person that has an artwork that is listed as treasury can actually never sell abroad such work. I was talking about the legal regime of exporting, but it is important also to explain what it means treasury and fund category. So what the Romanian legislator wanted is to preserve the most important artworks with an important value for Romania, but also a worldwide value. So for this, the goods belong to the movable national cultural heritage that are part depending on their historical, archaeological, documentary, ethnographic, artistic, scientific, and technical, literary, cinematographic, numismatic, philatelic, heraldic, bibliophilic, cartographic, and epigraphic significance of antiquity and their uniqueness of rarity. They were classified in treasury, which means that all the movable national cultural heritage that are of exceptional value for humanity, and they are classified as fund, which that would be cultural goods of particular value for Romania. So as long as an artwork is treasury or the fund, this means that all the procedure that was presented here must be followed in order for such artwork to be taken abroad. And also what is, as I told you, as long as a private artwork is also listed in the category of treasury, it can never be exported abroad. So this means that it cannot be sold. And this is quite a problem, a property ownership problem, if we can say so. But of course that the general interest of the national interest is above the private interest. So that's why the Romanian legislator established this restriction. So this was my presentation, and I'm looking forward for the question you have on the aspect presented or even other connected to it.
Thank you very much, Arcadia Hinescu. Very well noted, and thank you for the input, because I wanted, if some of our participant colleagues would be interested in making cultural projects, cooperations, including artworks from Romania, so that they may grasp the legal framework they need to know. What a pinpoint that maybe it would be of interest is if contemporary artists would like to collaborate, and one of them is Romanian and another one is a different nationality from European Union, for example, the contract, and they do a collaborative work, the contract should be based in one of the European Union countries, or should it be Romanian, or should they appeal to the collective rights management organization? So how would they deal with, for example, your example with the book, with the illustrated book, collaborative cultural good was a very good example.
Very good question as regards the law applying to the contract of a joint work. So usually if the two authors are from different countries, they should together decide. So how I see this is like the first one is looking into the national provision to see if there are certain restriction or certain favorable provision for their joint work. The other makes the same, and in the end they should choose the law that is the more favorable to their project. Of course, that I don't know if actually the authors make all this kind of work. They usually go to a lawyer, and the lawyer from to which they address to, as it is competent only for the jurisdiction in which in the country where he is a lawyer, he would most probably draft the contract in accordance with the national law. And what they could also choose is in case of misunderstandings, they can also choose not the Romanian court for solutioning the conflicts, but another court related to one of them. And but this is something that they will definitely need to talk about under which law they should submit the contract, because in the European law there is generally speaking there is no need to cover all types of rights and obligation, because usually the law already provides it. So you just make you just say that for this this contract shall also be complemented by all the Romanian legal provision applicable, for example. So the contract can be actually quite small from this point of view, like from the point of view of general rights or general obligation, but it's what the most important is for the artist to clarify is actually the role of each of them. For example, talking about the book, what is important is, for example, where this book shall be distributed, who will make the contract for distribution, who will, for example, they can also provide that the book can be the illustration for the books, and maybe some of the text, some parts of the text can be used in order to create other objects, for example, to be printed on t-shirts, to be printed on furniture. So there is another type of exploitation of their work. And it is very important to say who will do this kind of work, how much will take each of them for this work. That's why it is very important also to talk to a lawyer, but also, of course, I totally agree that they can also consult the collective management organization to help them with this kind of contract.
Thank you very much. And because we mentioned public cultural institutions, and Europeana is working with cultural institutions from the countries that are from European Union, maybe Ariadna, would you like to pinpoint? Actually, each country has one or several institutions that work with Europeana.
Yeah, for those who are interested in sharing data through Europeana, we definitely have like a contact point which we call aggregator, generally per country, and then we also have some thematic ones. So, for example, for photography, there's also a photography aggregator that institutions can address directly in order to submit content to Europeana, and then these organizations also. For example, in Germany, it's the German Digital Library, etc. So these organizations also are really good at offering advice in how to organize the information about the artwork and how to choose correct licenses and right statements, etc.
Thank you very much, because we talked about digitalization and open access and public domain, so that if someone wants to surf and then use different digital copies, so to say, so images from public domain from different countries, they can know where to start.